mention an issue on bankruptcy courts and accelerating a process that we've begun in Rhode Island, that exists in New York, that exists in the chairman's home state of Vermont. Very simple process. When someone files in bankruptcy court and they have a foreclosure issue, the court has a process that requires that they sit down, both parties, and discuss a modification before the process goes forward. It's consistent with Rule 105, which requires the parties to get together and have pretrial conferences and things like that. It has resulted in a flood of successful modifications. It provides, at least in Rhode Island, for mediation, potentially, but just getting people in the room together produces results. They have virtually never been required to actually take the step to mediation. What happens in this foreclosure process is that a human being gets run up against a gigantic bureaucratic system in which nobody they talk to on the phone will give them their last name, nobody will connect them to their superior, no one can be held accountable for any information, and no one has any authority to make a decision. So when they get to the bankruptcy court, suddenly, poof, you have a human being with authority and the applicant in bankruptcy, and they resolve it. And astonishingly, in Rhode Island, Deutsche Bank has filed a lawsuit. I guess they think it's a matter of significant interest to justify a lawsuit that they actually have to have a human being with authority talk to the homeowner before they throw them out of their house in bankruptcy. Seems a little bit of a stretch to me to require that. But I wanted to mention that we've been in touch with Senator Sessions' staff and other members on this subject. We would like to get a clarifying amendment that it's clear under the bankruptcy code that a bankruptcy judge has this authority to say to the parties, yes, you two actually have to sit down and talk like human beings before we throw this person out of their house. It changes no legal liabilities. It changes no legal priorities or orders. It is simply a procedural step of the bank having to sit down with the homeowner before they foreclose. And I think it would help develop this process across the country if we could resolve the issue in the litigation of whether the bankruptcy courts have this authority for once and for all. It's pretty clear that they do, but Deutsche Bank could spin this out for years, during which many, many homeowners will suffer. It's simple, it's clear, and I just wanted to inform my colleagues that we intend to look for a moment during this lame duck when we can take it directly to the floor. I think it is that simple and that clear, and just wanted to say that while we are here together, and I appreciate the attention that my colleagues on the Republican side have given to this measure.